The housing levy has been suspended. Here is what you need to know on how it affects you and your salary. To begin with, the Court of Appeal on Friday, January 26th, ruled that the housing levy would stand suspended until a case challenging its legality is heard and determined. The first case was filed by Senator Okia Omutata at the High Court, which he won, and the High Court ruled that the housing levy was unconstitutional, null and void. So the government, however, was allowed to collect the taxes for 45 days awaiting an appeal. That 45 days was to lapse on January 10th. However, the government, through the Attorney General and the Parliament of Kenya, went to court and got a different order from the High Court, which allowed the deductions to continue until the appeal was fully heard and concluded. However, the ruling on Friday by the Court of Appeal nullified that High Court order that had allowed the government to continue taking deductions, arguing that it was in public interest to suspend the deductions and then allow them if the housing fund is found to be valid. What does it mean for your January or February salaries? So for Kenyans whose salaries in January had not been processed, it means that they have a legal ground not to pay the deductions that stand at 1.5% for an employer and also matched by the employee at 1.5% of the gross salary. However, the ruling made on Friday, January 26, does not speak on how the deductions that had already been made from July 2023 will be handled. The ruling was on a different matter regarding on continued deductions, which will not apply to the deductions that had already been made. It is unlikely that there will be refunds, which is a big question. Many people asking whether they will get a refund, because the wording in the judgment mentioned that the government had requested that the deductions can continue, and if the housing fund is found to be illegal or null and void, then arrangements can be done for the refunds. However, Justices Achode, Justices Mativo, and Justice Gashoka, who are sitting on the Court of Appeal bench, ruled that it was in public interest to stop the deductions, arguing that it will be next to impossible to reverse the deductions if along the way it was found to have been null and void or illegal in that case. Money254.co.ke has written more about the ruling by the Court of Appeal. Click on the link provided to learn more.